Well, today we're looking at the interesting area of privacy law and how the media navigate privacy and how that balances against the right to free expression. You see, most of these areas we've been looking at involve a balancing act for legislators and the courts, balancing free expression against these other rights and interests that are enshrined in society. So, for example, in the area of defamation, it's a matter of balancing free expression against the right to someone's good reputation if they're deserving of that. And so we have this balancing process at play. And the same happens in privacy, because privacy is protected in those very same lofty international instruments that we saw that free expression is enshrined. UN International Declarations of Universal Declarations of Human Rights, and these sorts of international charters all protect both privacy and free expression. So internationally, what we have is this tension, and in some parts of the world, the courts or the legislators have developed privacy in a certain way so that it has more importance than free expression in those jurisdictions. In other jurisdictions, as the textbook explains, there has been emphasis on different parts of privacy rather than privacy as an amorphous whole. And in Australia, it's a good example of where privacy has mainly been dealt with through the Australian Privacy Act. It's been dealt with really to do with the holding of personal information about people by corporations and the potential for misusing that private information, your basic residential details and your political preferences and so on, the way they may use or misuse that for corporate or governmental purposes, rather than the media's intrusion into people's private lives, which has been a development in the law in some other jurisdictions. The UK is a good example of where privacy law has matured in the courts much further than it has in the Australian courts. And through the 80s and 90s and more recently, the British courts have essentially merged the areas of the action for breach of confidence that we heard about earlier and an action for a breach of privacy. And they've done this in the area of celebrity legal suits. And of course, others have also been involved, but the most famous cases are those that have involved some of the world's leading entertaining and sporting figures who've gone to the courts, sometimes using the breach of confidence action, but essentially to keep the media out of their private lives or to punish the media through an award of damages for what they believe was a gross and unnecessary intrusion into their private lives and perhaps revealing private facts about them. And the textbook details those cases over recent decades. There are also very important digital dimensions to privacy law. Because there are differences throughout the world in privacy legislation, and because the internet is a global phenomenon, what you get are people who are coming from a place with a certain interpretation of privacy, and they are operating on the internet, perhaps engaging with you in Facebook or Twitter or other social media comments, perhaps producing a blog. But they are bringing certain understandings and expectations of privacy to their work, which may be in conflict with our view of privacy. At its extreme, of course, we get practices like trolling, where there are actually laws that prohibit this sort of thing. In Australia, at a federal level, we mainly combat trolling or cyberbullying via a federal law against the misuse of a communications device. And so there aren't formal cyberbullying laws. They have adapted these other laws for that purpose. But nevertheless, the authorities do take action against people who engage in that. But digitally, it's very hard to combat someone who's trolling you from some remote jurisdiction elsewhere. And that's the problem the courts face. There are also data protection laws. Now, the Privacy Act is its own kind of data protection law. It's protecting your private data from being misused by companies and government organisations. But nevertheless, there are also special data protection laws in place, and some of these apply to the media, but there are also intrusions into data protection that we learned about in national security, our national security topic, where federal agencies are able to usurp such data protection laws and force companies to retain metadata, which the security authorities can then access and find out private details about you and your conversations. Well, where is the notion of a privacy tort in Australia? Now, law students would know that a tort is a civil wrong. It gives you a legal foundation to launch an action in the civil courts to sue someone for some damage to you as an individual citizen. Another civil wrong, a common one sued over in the courts, is the area of negligence, for example. But in some jurisdictions, there is a civil wrong, a tort of privacy, where you could actually take someone, perhaps a media organisation, to court and sue them for an amount of damages if they have intruded into your private life. Well, in Australia, such a tort of privacy, a legal action for privacy in that regard, has been very slow to develop. And the textbook explains that while it is recommended that there be a new tort of privacy intrusion, it's been recommended by law reform commissions and has actually been proposed by some recent governments in Australia, it has yet to work its way into legislation, and we have yet to have very high superior court decisions establishing a tort for serious invasion of privacy in this country. Now, as I say that, it could be happening at this moment because we've pretty much been on the crux of a new tort of privacy for some years now, and during the space of this course and this edition of the textbook, it could well be that a new tort of privacy is introduced either through the Parliament or through a superior court decision. The textbook does talk about the High Court case, the Lanarr Game Meats case, which did not rule out a new tort of privacy, but the High Court chose not to establish one at that time. The New Zealand High Court has developed a new tort of privacy and has actually implemented that through a series of decisions. In Australia, we've had several decisions that have gone to a district or county court level, that intermediate court level in different states and territories, some involving the media, but the media have not chosen to appeal their loss of such right to privacy cases to higher courts. I think because they fear that the higher court will actually entrench a new right to privacy through such an appeal. So there have been these reform initiatives, and the reforms have come both from the legislature, recommending by some parliamentary committees a new statutory tort of privacy, and through the courts, through judges in some courts recommending that. There are other areas of the law that relate to the general umbrella area of privacy, and two of those discussed in the textbook are the areas of trespass and nuisance. Now, these are important areas, and you would understand that particularly for journalists, the area of trespass is very important because sometimes their work requires them to go onto other people's land or premises to report upon a story. So you would be wise to look at the ingredients of a trespass action and particularly look at the defences that might be available through your closer reading of the textbook and your engagement in the other activities. The area of surveillance and obscenity are related to privacy as well. We've talked a little bit about surveillance laws, but most states and territories do have surveillance or listening devices acts which do impact upon journalists and other media workers, recording of phone conversations, use of secret cameras, these sorts of things. And the laws do vary a little between different states and territories, as explained in the textbook. I'm imagining most people working in the media from graduating from this course aren't going to engage in the publishing of obscenity. And we hope that that's not your main business coming from the course. And there are strict laws concerning the publication of obscene materials, which again vary across jurisdictions. And this is the reason why in adult stores in some jurisdictions of this country, certain publications may be available over the counter or plastic wrapped. Whereas in other jurisdictions these publications may not be available at all. So there are these obscenity and restricted publication laws that you would need to be aware of if you were venturing into that area of publishing. The final thing is that there are all sorts of ethical regulations related to privacy as well. The Australian Communications and Media Authority has its codes of conduct policed by the different industry groups, the commercial radio, commercial television, pay television, community media and so on. And each of those has a code of practice which has provisions talking about your intrusion into the private lives of others and unnecessary intrusion. Similarly, the Australian Press Council and the Media Entertainment and Arts Alliance, through its Journalism Code of Ethics, they all have restrictions on the media's intrusion into people's privacy, normally with a public interest excuse, but nevertheless, as we see cases come through and exposés on Media Watch style programs, we're finding journalists are becoming much better educated in this area and see it as quite an important ethical breach if they unnecessarily intrude into someone's private life. More on that in the text, and please go into the deeper readings and deeper understanding through the other learning activities you're finding in the course. I hope you're enjoying it so far. See you next time.